Okay, we're back from break and it is 7:08 p.m. We're going to take up item 6C, which is discuss and take appropriate action on the following: a proposed master agreement and other ancillary agreements between Central Health and Seton Healthcare Family. Welcome.
Thank you. I'm John Stevens. I'm a project manager for Central Health, working on the negotiations with Seton, the 1115 waiver, and other things. And I'm here tonight with David Hilgers, our outside counsel, who has worked with us. We have been, as you guys know, we've been working on this for a long time, since the board passed the letter of intent back in April of 2012. So the first thing I want to do is to recap the presentation that was made on May the 1st. That was the first presentation where we sort of took a steady focus on everything that we've been doing on the Community Care Collaborative, the CCC, with Seton, and the master agreement and the other two ancillary agreements related to that. So just recapping that quickly, as we pointed out, there has been a public-private partnership model in place for hospital services since 1995, initially with the city, of course. The current model needs to be updated to integrate primary, specialty, and acute care and to provide a more sustainable source of funding. In fact, part of Seton's focus in working with us is really to keep people out of the hospital. So that's there have been a number of sea changes in the medical industry since 1995, and there are still a lot of changes going on. And one of those is for hospitals to try to begin to actually shift their focus on trying to keep people out of the hospital. And it's sort of like the model that the city of Austin had for Austin Energy. How do you earn money when you're producing electricity, so how do you do things like conservation, put a focus on conservation? And so it's going to be a big change to the model. The 1115 waiver and the 10 and 10 initiative have provided us the opportunity to update the model, and the master agreement along with the Community Care Collaborative will provide the legal and administrative infrastructure to actually implement that model. The master agreement is based, and it's entirely consistent on the April 2012 letter of intent.
John, can I just add in, because I heard one of our speakers mention earlier about, use the term privatization of the hospital. And could you explain a little bit more about what that public-private partnership since 1995 represents, the difference between ownership of the building versus ownership of the hospital operation?
Right. Well, it was an effort in 1995, again, when there were a lot of changes going on in the hospital industry here in Austin. It was really an effort for the city to try to maintain control of the hospital, the facility that it had built and operated up until that time. But to do that in a way that would permit a private operator to operate the hospital with the flexibility that the city didn't have because of requirements for its own purchasing and things like that. And so it was, I think, a true public-private partnership. It really was more of a contractual arrangement at that point than the agreement that we have in place with Seton. I'll talk a little bit more about that in a moment. But it was really just the opportunity to take advantage of what the private sector can do with a single focus on providing services and still maintain the public's interest in the types of services that are provided and the population that they're provided to.
So Seton, as the operator of the hospital, they had the hospital license, they had the hospital provider number, they employed the staff, it was their equipment, they arranged for the doctors to provide care there. That was part of the whole Seton Healthcare Family operation.
That's right.
And that's distinguished from ownership of the building. The building is not the hospital operation. It's where the hospital operation takes place.
The building is not the hospital operation. Actually, the definition of hospital in the dictionary is an institution. It's not a building, it's an institution. And of course, Seton was already operating other hospitals in Austin and Travis County at that time. So they took over, they took over the staffing as it was then under the city, but
Tricia,
folded it into their operation.
I like to take a legalistic attitude point of it. The hospital is the entity that owns the license. That's what the hospital is. And they run the hospital, they operate the hospital. The building owner could be me. I could own the building, and I'm not a hospital. I do own the facility, but I do not operate and run and own the hospital. So that has been the situation since 1995. That
So the hospital has been
owned by Seton since
1995.
Isn't our deal with Seton, and it has been from the beginning, is that while our patients can go to Brackenridge, they can also, I mean, their obligation is to take care of our patients at any of their hospitals,
That's
and our
right.
patients can go to any of their hospitals.
That's correct.
It's
and
just that a
runs
lot of
all
our
the way-
patients show up at Brackenridge and they're prepared to take them there.
That's right. That goes all the way back to the 1995 lease, where their commitment was to provide services anywhere a patient presented.
Okay.
Just a quick overview of the master agreement. It replaces or updates the UMCB lease as the document that governs the relationship between the two parties. It really is more of a collaboration than a contract between the parties in a number of ways. It's also an extension or an update to the 2007 private UPL or uncompensated care agreement between Central Health and Seton. That agreement rescinded that long standing medical access program agreement under which Seton was paid by Central Health on a per member per month basis for the MAP population, and that was replaced with the UPL affiliation agreement under which all payment terms regarding MAP were rescinded. And so essentially, under that current agreement that's in place right now, Central Health has no contractual obligation to send up an IGT for Seton, and Seton has no contractual obligation to provide services to our MAP population. But certainly both parties have fulfilled the intent of that UPL agreement and will do the same thing under the master agreement. So this is not a contract like an IT services contract that you think of, for example, where if this person doesn't, if your provider doesn't do this, have the network up like it should, it can pay you a penalty and so on. We can't have a quid pro quo like that expressed in the agreement that we have with Seton under state law. It will provide, the master agreement will provide for Central Health and Seton to make joint decisions about the management of the MAP population, the number of people that are covered, and the benefit plan that's offered. It'll offer an opportunity for joint management of and oversight of the Deseret projects and the expansion of primary and specialty care, and allow us to integrate and manage the provider network. Understanding that, again, there's going to be a focus to keep people out of the hospital, and so we're trying to shift some of the activity that goes on in the delivery system now over to the primary care and specialty care side. The initial term of the agreement will be 25 years with automatic successive 5-year additional terms by mutual agreement. I want to move to Article 3 of the master agreement. And
John,
talk
what's
about-
how long is our agreement with Seton now? What's the term, the remaining term of our agreement with, such as it is?
I think there's 33 years left
Okay.
at this point.
Thank you.
50? It was 50 or 60, I can't.
It was 50 years initially?
33 years. It was
No, 33 years remaining, though, is what you
Remaining,
said.
yes.
And we've been in it how long?
17.
Okay,
Okay.
yeah, almost
Right.
18 years.
Okay.
So it started out, I believe, as a 25-year agreement and then was changed during the second lease amendment to a 50-year agreement.
Okay.
Article 3 of the master agreement speaks to governance. Governance of the CCC, the Community Care Collaborative. As you know, there'll be 2 initial corporate members, Central Health with a 51% membership interest and Seton with a 49% interest. So Central Health has a majority ownership, but importantly, there are powers that are reserved to both parties, and there are material decisions that require a supermajority to be effective, to be put into place. And we'll talk a little bit more about that in a minute. And the master agreement contemplates that there will be additional members and or new classes of members that may be added, again, by mutual agreement, as long as they are wholly committed to the CCC's mission, purpose, and objectives, that they demonstrate a commitment to provide substantial services to our population, that they agree to an appropriate financial commitment and acceptance of financial risk. As you know, it was good to have Fred and Dawn here tonight, because we anticipate, there has been some discussion, and we anticipate that ATCIC will be probably the next member to roll in with us, and I think that's really a good thing. Certainly in the letter of intent, one of the priorities of this board was behavioral health and mental health services. And so I think that would be a logical fit to have ATCIC be a part of the CCC and work cooperatively with us. There'll be an initial 5-person operating board of directors composed of 3 Central Health Board of Managers appointees and 2 Seton appointees. Each party will then have the unilateral right to select, remove, and replace its appointees. And the parties may mutually agree to change the size and composition of the board, add more members, or whatever. The CCC board will have authority by majority vote to make all decisions and take all actions for and on behalf of itself, of the corporation, except for decisions and actions that are reserved to the members. Section 3.8 of the master agreement talks about reserved powers. And Section 3.9 goes over material decisions, and we're going to go through those right now. Here you see a list of powers that are reserved both to the Central Health Board and Seton's board under Section 3.8 of the master agreement. I'm not going to go through these, each one individually. Just point out to you that items 1 through 7 are in general changes to the governance of the CCC. So these are powers that are reserved, that have to be approved by this board, the Board of Managers, and by Seton's board in order to be effective. Then moving on from items 8 forward, for example, the rest of these have to do with more of the actual working of the corporation itself, like number 8, where this is a reserved power to the creation of committees. All of the committees that are created and appointments of officers or committee members will be a reserved power of both entities, as will item number 9, for example, approval of annual budgets, fiscal and purchasing policies. Item 12, adoption of the business and strategic plan. Number 13, determination of the covered population. And then on and on as you see. And down to item number 18, approval of the coordination and funding of the federally qualified health centers, the FQHCs, that are set forth in section 4.5 of the master agreement, and we'll have a separate discussion of that in a moment. And then, again, in addition to the reserved powers, there are certain material decisions that have to be approved by a supermajority of the CCC board. Supermajority meaning 2 members, 2 Central Health appointees, and both of the Seton appointees to the CCC operating board. And so these 4 powers are material decisions that must be made by the supermajority. Then, in addition to the reserved powers, Central Health has the following unilateral rights. Clearly, funding of IGTs and the funding to the CCC and integrated delivery system are a unilateral power of Central Health. Central Health is under no obligation, no contractual obligation to make IGTs, but does so at its sole discretion. Number two, approval, support, and funding of women's health projects or other projects deemed necessary for the community by Central Health that Seton cannot carry out due to ethical and religious directive restrictions. So Central Health has the unilateral power to carry those projects out.
So that means we can go out and purchase those types of services wherever we may deem necessary.
That's exactly right.
And there's no way that Seton can overrule us
No.
and say, no, that couldn't or shouldn't
No.
be done.
They cannot
Because this
interfere.
is a unilateral right reserved to us.
Okay.
Also reserved to us is approval, support, and funding of any type of project that we would have to carry out in order to be in compliance with our enabling legislation under state law. And determination of Seton compliance with any agreements between Seton and the CCC, and on behalf of the CCC, the right to enforce any agreements between Seton and the CCC. And on the next page, similarly,
John,
you'll.
we have
Yes,
Would you
uh-huh.
just restate that in a more simple way?
Yes.
What you mean by that, please?
That means that we will be the only party that will judge, that will determine Seton's compliance in any agreements that exist with the CCC.
And is it,
They have, Seton has the,
bilateral?
No.
yes.
To us?
Seton has the flip side of that,
Okay.
right.
It just means that, I mean, a judge eventually would decide who's in compliance and who's not, I guess. But
Right.
it would enable us, if it's a deal between the CCC and Seton, to decide that we're going to enforce that agreement in some way. And the flip side is that if it's an agreement between us and the CCC, then Seton could enforce the agreement in behalf of the CCC.
And most likely, there are going to be many more agreements between the CCC and Seton than there are between us and the CCC, because
Right.
Seton will be a provider.
And then Seton has the unilateral right to determine the locations, whether either directly or through other providers, it will provide services to our covered population. But they have committed to us that they will consult with us well in advance of any major changes of location. Going to the next page, we had some sections in here on the CCC bylaws, and we took them out because they made the presentation a lot longer. But Articles 3.10, 3.11, and 3.12 of the master agreement really speak to the same issues of governance that the CCC bylaws do. So everything that's in the master agreement is consistent with the CCC bylaws. There's nothing that's inconsistent with it.
Madam Chair.
Yes.
Circling back to a discussion we had earlier about transparency, from looking at this, it looks like we have pretty well covered all the big issues that will have to come back to this board for approval. And there's also an agreement, I believe, in the CCC that the meetings, some of the meetings, all of the meetings, I don't remember now what it is.
There is a commitment to a public meeting at a minimum of every 2 months.
A minimum.
Yes, 6 times a year,
Okay.
or every 2.
So there'll be a lot of opportunity both for this board and for the public at large to be aware and involved in the CCC
Yes, there will.
operations.
Yes, there will. And as a matter of fact, just logistically, I don't know that it's going to work out this way, but to me, it would be logical for those meetings to be held in the same location here where the board meets, so that, they might be a continuation of the board meeting. At the city, for example, we had corporations that the city would recess and then go into a separate session for the Austin Housing Finance Corporation, for example, then recess that and go back to the board. I'm not suggesting that would happen here, but it could be that just for convenience to everybody involved, that the meetings be next to each other.
I want to ask Trish a question. Trish, about how often do you see you updating and giving presentations to us as a board here on the CCC?
Probably the same reporting that you have right now on all service delivery, which is monthly. You get monthly reports, you get quarterly reports, you get annual reports, so you'll have the same level of reporting in terms of service delivery and who's being served. It's just, you're basically getting the same information that you get now, but actually probably more robust information, because you're getting reports on the MAP population and the services delivered and the cost of those services, et cetera. So you will have the same.
And
the same
initially,
reporting.
like when we really first get started, do you see that being almost at every meeting because of all the decisions that might be
Well,
made?
quite frankly, in terms of implementation over the coming months and through probably between now and the next fiscal year, you're going to be talking about this at every meeting, if not us scheduling additional meetings for you to take implementation actions, such as approving initial contracts and transfer of contracts, et cetera. So you're going to see a lot of activity for the coming months, probably more than you'll want to by the time it's all over. So yes, there's going to be a lot of information brought here.
Okay, thank you.
I want to move on now to Article 4 and talk about the funding and the budget process. Take a slight detour back to Section 3.1 though, because it kind of sets the preamble, I think, for how the parties will work together on funding the CCC and the IDS, the Integrated Delivery System, which is really sort of a larger concept. The CCC is the corporate entity. The IDS includes the CCC, but it also includes other providers who are not necessarily members of the CCC, for example. And so Section 3.1 speaks to the Integrated Delivery System and says, the parties acknowledge and agree that they desire to coordinate all available healthcare resources to organize and implement an IDS, et cetera. So available resources means the existing resources that the parties have historically contributed, and it also means new resources intended to enhance the delivery system, property tax, federal matching funds, for example, and Seton funds. And let me talk just a little bit more about that. Central Health will use its new tax resources, its new tax revenue that the voters approve, first to leverage federal funds that are available through the 1115 waiver or any other program. In other words, we will try to use that new tax revenue as a local match, as an IGT, either for the waiver for uncompensated care or for the DSRIP side of the waiver, however we can. And we will also use those new resources to enhance services that will be available through medical education. Then both parties, including Central Health, will use their new resources as available to expand primary care, specialty care, and behavioral health care services, and to integrate the delivery system. On our side, for example, anything of the new property tax revenue that we do not have to use for an IGT, we will, in general, make a direct payment to the CCC just to fund additional services with whatever excess of that property tax revenue. And we will, both parties, I think, will commit existing resources to the CCC. For example, Central Health will contribute the funds that it spends on the eligibility program, for example, because eligibility will be carried out for the covered population within the CCC. For example, the payments that we make to Sendero to manage our vendor contracts, which will be transferred over to the CCC as much as we can reasonably do. So the way the process itself will work is that each year the parties will review their financial situations and coordinate the resources available to fund the CCC. We will, both sides will really know what's at stake here, and that's fine. As the people from the Health and Human Services Commission say, both sides in an agreement like this one with Seton can be self-aware, they can be aware of what the other party's doing. There simply can't be any contractual obligation, for example, for us to make an IPT. So upon execution of this master agreement, the parties will collaborate on a budget for the initial partial year, which will go through September 30th. That's what Katrina was referring to earlier. I think y'all got sort of a first look at that. And our, just to continue that discussion for a moment, I mean, our intent with that is we want to get an initial budget in place as quickly as we can, because we cannot let a contract, for example, for somebody to carry out a Deseret project unless we have an appropriation within the CCC to do that. So we'll set up an initial budget just to do that alone, and then we'll probably come back to amend the partial year budget as we get more information, as we know what's going to happen between now and the rest of the year. And then at the same time, we'll collaborate on a budget for the CCC's first complete fiscal year, which will begin October the 1st of 2013, the fiscal year being 2014. It's the same fiscal year that Central Health has. And then on an ongoing basis, by March of 2014, the parties have committed to begin work on the next year's budget, which in this case will be the 2015 budget, which will also include a 3-year operating and capital forecast. And so that same procedure will then continue on an ongoing basis. Then lastly, failure to agree or upon or adopt a budget constitutes what's called a funding deadlock, and we'll talk a little bit more about that later. That funding deadlock will trigger a dispute resolution process that we'll go over also. And during that time, if there is a funding deadlock, the prior year budget simply remains in effect if we can't agree to the new year budget. Section 4.4 has to do with transition funds. As it says here, the parties agree that Seton has to invest significant direct and indirect costs and expenses related to new services, to expanded access, and the transition of its care model for the safety net population generally. Again, just going back to the remarks I was making earlier, they're really changing their complete focus to try to get activity that happens where possible outside of the hospital, where it's much more expensive to provide that. But it's going to take a lot of effort for them to go through that, coordinating all the sites where they now offer services, in addition to coordinating with the teaching hospital, with all the other sites, and coordinating with the medical education program that will be expanded through UT. So Section 4.4 provides that they will use up to $20 million of their per year of their funds for expansion of that system. That is money that we know would otherwise be considered available resources for the covered population. This use will be for no more than a period of 5 years, and it is subject to an analysis of financial performance of UMCB or the teaching hospital as appropriate. In other words, Seton is going to use this money to invest and to transition its system. At some point, the hope is that that will be financially beneficial to them and to us as well. And I think they are committed to trying to do that, but we wanted to make sure in negotiating this provision that if their financial performance improved, actually during the time when we were implementing the waiver, for example, that we would be able to sort of claw back, as it were, some of that money, so that if their performance improves significantly in any of the 5 years relative to the base year for either UMCB or the teaching hospital, then a portion of that amount by which its performance has been enhanced will be put by Seton into the CCC. And the measure for gauging that is a definition that we agreed on, the adjusted gross margin for either UMCB or the teaching hospital, again, as appropriate. Section 4.5 has to do with the federally qualified health centers. And as it says here, both parties acknowledge and agree that the success of the IDS depends on the effectiveness and efficiency of the primary care delivery system. As you know, there are 3 FQs currently operating now in Travis County, the largest being Community Care by far, then Lone Star Circle of Care and Peoples. And they do form the backbone of the primary care system that we will be relying on as we transition to this new model of delivery. So the efficiency of the delivery system for us will depend on the commitment and cooperation of the FQHCs here in Travis County who provide services to our population. So we and Seton agree to cooperate through the CCC in contracting directly with each FQHC, and will collaborate to determine the appropriate level of reimbursement for the services that each FQHC performs. Moving on, it says the FQHCs will also be required to demonstrate and comply with productivity and quality standards that the CCC develops and upon which reimbursement may be contingent. And this would apply to other providers who are not FQHCs as well. Because as you know, the CCC has been modeled and was actually named for a pilot program that the federal government is implementing to try to move healthcare delivery towards an ACO or an accountable care organization. And so that is very much of what we're about here, is to try to move to the point where we are able to implement accountable care-like standards, which may include different methods of reimbursement other than what we're using right now. So specifically, Central Health and Seton agree that they may take action to ensure these 2 things. Number 1, that we can preserve Central Health's FQHC co-applicant status and funding eligibility with community care, that these aren't jeopardized in any way. But at the same time, we also want to enable the expansion of any FQHC's operations, make sure that those expansions within Travis County are not jeopardized, that we don't take any action that would jeopardize that. Section 4.6 talks about the services agreement, and I'm just going to speak to this in general right now. We are still, actually we had a very long meeting yesterday on the services agreement with a number of people there, and we're making very good progress on this. But the intent of this agreement was to establish the baseline for the current level of services to be provided by Seton to the MAP and charity care populations, as well as the value of those services. And this really dates again back to the letter of intent that the board approved in April 2012, where under that letter of intent we agreed with Seton that, or Seton agreed that they would continue to provide the same level of service they have provided historically, currently, for the same level of compensation that they have received historically or currently. And so we've spent a lot of effort on making sure that both parties understand what that is, and I think we're getting very close to a good product on that.
And John, on that, when you say for the current level of compensation that they receive, that definition is inclusive of any payments that may receive directly from Central Health. For example, I think we make a charity care payment to them each year, but also the federal funds that they've been receiving from the federal programs that are facilitated by our intergovernmental transfers, which represent their reimbursement for the services they provide.
That's exactly right. That actually that federal funding comprises the bulk of it, the compensation that they receive, but it also does include, as you said, the charity care payment.
Okay.
John, for the second bullet though, where it says it provides a process for changing this level of service, you mean doing an add-on? We have the current floor of service expectations, and then what we would go through to increase that level. on top of the current floor.
Yes, and that is something else that will actually be carried out by the CCC, but it will be, once we get this services agreement in place, we want to make sure that what happens within the CCC between the parties is also reflected in the service agreement. In other words, if there are additional services added, if the MAP population is expanded or whatever, that will be reflected in an updated version of the services agreement.
One
In
of
a
the-
future
In the
updated
future.
version.
Yes,
Oh, okay.
yes.
One of the real problems is when you have an agreement like this, it does change. It changes all the time because the need for services change, the type of services you're going to provide change. But the problem is nobody documents it. So people will be doing things that are not like the contract says. So what we try to do is provide a process and say that there can't be any change without going through that process and a definitive written amendment saying this is what we're doing. So that's the process we're talking
Okay,
about.
thank you.
And as David said, that's something that just happens sort of as a normal course of events. One of the things that we discovered on both sides was that depending on which service or which contract it related to or whatever, over here in Seton, Joe had that contract and Sue had this contract, and so it was really quite an effort to just get all this stuff together and document what's happening right now.
Throughout their system.
Right,
Because it wasn't
throughout
just
their
about
system.
Brackenridge, it's
Mhm.
what's happening
Mhm.
throughout the system.
So that really took a lot of work, but again, I think we're going to come up with a good product on that.
So John, if I may, if I were a MAP patient, my main concern is, am I getting the same services
Yes.
under this new agreement?
Absolutely.
Yes.
Okay. But in addition, which they can do right now, but I guess most people just go to Brackenridge, but they can go to any of the Seton hospitals.
That's right.
Okay, so
That's
somehow
right.
we'll have to get that out there, because I don't
Right.
think
Right.
people
Well,
know
that-
that.
that-
Yeah, and I guess that's a fair statement around, for example, the emergency room.
Yeah, but not for
not all,
admissions.
not every service is offered at every hospital. Many services are concentrated because they're specialties or because it makes sense for them to be in one place or the other or a couple places.
And
but-
patients end up where their physician admits them.
Yeah, that's true.
That's right.
That's true.
right.
But I'm just wondering if we could kind of put that out there at some point, regarding which hospitals they might go to, I don't know, on the CCC website. I don't know, I'm just thinking out
yeah,
loud here.
and again, I think it's actually, I'm glad you brought it up because I think sometimes there's a misunderstanding and you just hit the nail on the head, Lynn. Folks, if you're going to an emergency room, you go to whatever that emergency room is and you receive care there. But when you enter the hospital for anything else, whether you're there for a procedure or for some testing, you don't just show up and ask for it. You are directed there by a clinician's request. So your clinician is going to direct you to that service based on what you need and where that arrangement is. So it's not a system where people just kind of wander around and decide to go get something here or there. They're directed by their physician or whoever, what clinician's taking care of them. And that ends up dictating where they go.
That's true. And also we have to remind everyone too that Brackenridge is a Trauma One center, so.
Right.
That's right.
That's really important too.
Yeah.
Okay.
That's a good point that you bring up, Rosie, and let me use that as an opportunity to say that, again, you all had a presentation, the first presentation of a series of 3 on May the 1st. This is the second. And then next week, we hope to come back with a presentation that will do, I think, what you're asking for, and that is it'll really show better what the benefits of what we're doing and how they'll affect our population and be spread throughout the network. So that is what we're trying to do. Let me also just say, I meant to say this at the beginning, but the intent of this presentation was also to serve as a sort of a layman's guide to the master agreement, because it's easy to get lost in the master agreement. It's dense, it's hard to read sometimes, and it references other sections that you have to go back and forth in. And so we've tried to make this entirely consistent with the terms of the master agreement, but the sort of Cliff's Notes guide to that. And so we hope that it will serve as the written documentation for that, for those who don't want to wade through the master agreement.
It's helpful with your board members, too.
It's helpful for staff, too. Section 4.7, going back to the ethical and religious directives, we both acknowledge that Seton must comply with the ERDs for Catholic Health Care Service. This is also something that was in the 1995 lease, so it's been consistent throughout. And it says that the parties will not take any action that would cause Seton to violate the ERDs, or the IDS will not operate in any way that would cause Seton to violate the ERDs. Now let me say this another way, because this is not saying that we can't do something. Central Health can take actions even though they violate the ERDs. We can't take actions that would cause Seton to violate the ERDs. We can do whatever we want, but we simply can't take an action that would cause Seton to violate the ERDs. And the IDS can't operate in any way that would cause Seton to violate the ERDs. But again, we'll be able to carry out any activities we need to do, either through our own funding or through other providers that we have in place for right now, for example, Planned Parenthood. So Seton is supposed to notify us if it determines that any provision of the agreement would cause them to violate the ERDs. And if an ERD issue arises, we'll work cooperatively to transition whatever activities are involved in that to other third parties. And again, at a minimum, we have the unilateral right to assume and pay for the provision of those services through other providers. Section 4.8 speaks to the teaching hospital, and as it says, subject to approval by Ascension Health, which we expect will happen very soon, Seton will design, construct, equip, and operate a hospital that will function as the teaching hospital to the medical school, function as part of the safety net system. Seton intends to take commercially reasonable actions to obtain and maintain Level 1 Trauma Center certification for the teaching hospital, or other such similar certification if Level 1 does not exist. Their intent is to reach Level 1 certification. They simply don't want to put that as an absolute commitment, because they don't want that to be a breach of the agreement that they've not been able to do for reasons that are entirely understandable.
And John, if I remember correctly, it was because they intend and hope to transfer the designation. They just don't know yet if that designation can be transferred.
That's exactly
And that's
right.
why it's written this way.
That's exactly
But
right.
their intent is for the new teaching hospital to be a Level 1 trauma center.
Yes.
Okay.
And if you can't transfer it, what happens is you have to be a level 2 first. You can't be a level 1 until you're a level 2 for a period of time. Then they test you and see whether you're level 1.
Okay.
So that's
Okay.
a technical violation.
And then the last note here is, as y'all know, we have also committed to we will commit to a mutually agreeable lease for the existing UMCB facility and any future services or programs. And so that is the other ancillary agreement besides the services agreement that we have been working on for some time with Seton now.
John, you skipped the part about the lease. Do you want to just,
Did I?
desires to lease, own or lease the site?
Oh, I'm sorry, yes. The fourth bullet point there, we desire to own or control through a priority lease the site of the teaching hospital, and we agree to work in good faith to achieve this objective. And there has already been a lot of discussion between the parties and UT, and I think at this point all signals are go. So we don't know when that's going to be finished, but it is definitely in the works. As you guys know, UT is really taking some very significant prompt steps to get the medical school in place and allow for the siting of the teaching hospital.
And the Regents did take action last week to approve a priority lease as opposed to a sale to us.
Section 411, the medical school, Central Health. This is very brief. It just acknowledges that we agree that UT intends to construct and operate a medical school at or near the UMCB campus, and will work cooperatively together with UT in the development and funding of a medical school. And again, that's an activity that has been ongoing, had meetings last week and this week both, so all of this is underway. Okay, Article 6 goes to termination. And let's start off, the master agreement, there are a number of ways that it can terminate, but one way is it can terminate simply by mutual agreement of the parties. Then Central Health has the right to terminate the master agreement for one or more of the following events of Seton default. And as you'll see, a lot of those, the first 4 of those have to do with really Seton changing its mission or changing its composition, either because it's insolvent or because it changes to a nonprofit corporation and becomes taxable, for example. But then another event of default is if they offer to sell to someone or give up control of the teaching hospital, that is an event of default. If they abandon the teaching hospital, or if for whatever reason the teaching hospital is no longer a part of the safety net system. So essentially 3 categories: either they're insolvent, or their form of governance changes, presumably their mission changes at the same time, or we lose the teaching hospital to the safety net or for the safety net system.
John, the offer to sell, though, the offer to sell has to come to us first, right? Maybe because that would be a default. So how would that work?
I'm sorry, which one?
On 1, 2, 3, 4, 5, the 5th bullet, Seton offers to sell. That would become a default, but then who would they sell to?
Well, if they defaulted, we're leaping ahead on John's presentation, but if they
Oh, okay,
defaulted,
sorry about that.
we would have the option to buy
Okay.
for cost
Okay.
the teaching hospital.
Okay,
Right.
So
then I'll let you continue then.
Right. Okay. Seton can likewise terminate for one or more of the following Central Health defaults, and these are all related to insolvency. If we file for bankruptcy, make a general assignment of benefits for creditors or whatever, all relating to insolvency. Then either party can terminate as a result of, may terminate as a result of a breach by the entity of the master agreement or of an ancillary agreement. They don't have to terminate, but they may. For example, if one party believes the other has breached the master agreement, and a breach would be a material non-compliance with the agreement. For example, if Seton stopped providing services or stopped providing the level of services that they had committed to, that would be a breach of the master agreement. So if one party believes the other has breached it, we have to provide written notice to Seton if we believe they've breached. And then it can be cured because if there's no dispute regarding the breach, if they say, yeah, you're right, we did that inadvertently or whatever, they have the right to cure that within 60 days. But if they do not agree, if there's a dispute regarding the breach, then we have to provide notice to the first party, and this triggers the dispute resolution process that we'll talk about in a moment. Other grounds for termination include either funding or governance deadlocks that persist for 6 months. At that point, if we have a funding deadlock for 6 months, either party may terminate. Again, after going through a dispute resolution process, during that time, the master agreement remains in full force during that process. A funding deadlock would be, for example, failure to agree on a budget, as we talked about earlier. We would leave the prior year budget in place, but if that goes on for 6 months, that could trigger a funding deadlock. A governance deadlock would be, for example, an inability of one party to exercise its reserved powers or to render a material decision. So then if either party determines in good faith that the other party has not funded the CCC from reasonably available funds, as we understand that, that can also terminate after the dispute resolution process.
So this is the second thing, bullet, John. It's not under deadlock, it's another reason for grounds of termination.
Yes.
Oh, okay.
Moving on, other grounds for termination, if Seton fails to construct the teaching hospital within a reasonable period of time. And what this means is that they've gone through and obtained all the permits and licenses that they need to begin construction of the hospital, but reasonable is going to depend on circumstances to some case, but if we think they have stalled and have failed to construct the hospital, then we can move for termination. Likewise, if we can't agree on a ground lease for the teaching hospital, or if there's a change in law that affects the legality of the master agreement and it's something that neither party can fix, then those would also be grounds for terminating the master agreement. So let's talk about the dispute resolution process. If that continues for 60 days, then we have to initiate a dispute resolution process. And again, the agreement remains in full force during that process. The dispute resolution process starts at the top, and it says that the president and CEO of Central Health and the president of Seton will meet promptly and attempt in good faith to resolve the dispute. If it's not resolved within 30 days of receipt of the notice of dispute, then the parties will submit it to mediation, observing protocols for the mediation that are discussed in 731 of the master agreement. And if it's not resolved through mediation, then either party may seek judicial resolution at that point, go to court. So let's say that we've gotten through termination and we're in the post-termination phase. The parties agree that upon termination of the master agreement, all the funds that are held in the CCC will first be used to pay any outstanding obligations, and second, they'll be used to continue to fund healthcare services for the covered population. Then, importantly, this is a significant provision for Central Health, that Seton has agreed that if the master agreement terminates, they will provide what are called post-termination services for an initial 5-year period, the first 5-year period, as follows. They'll provide the same inpatient and outpatient services that they provided in the last full calendar year before termination, and they'll be reimbursed. They'll receive the value of reimbursement, again, the same as was provided to them in the last year, but it will include a CPI adjustment only if it's due to a Central Health breach. Otherwise, there is no CPI adjustment. The same amount of compensation gets paid without inflating it through the CPI.
For 5 years.
For 5 years, for that initial first 5 years. Now, the significance of this, as you guys know, is that under the current agreement, neither party has any intent to, to end the current agreement. We want to amend it and carry it forward. But Seton would be able to terminate right now and pay us a penalty of approximately $35 million and walk away. At that point, they don't have to meet any obligations other than what they have to meet under state law because of their hospital license. They have no continuing obligation to see our MAP patients or anything else. So this is a very significant win, I think, for Central Health in this master agreement. And then even as significant is that Seton has also agreed that, again, These will survive the termination of the agreement, these two provisions. But they've also agreed that for a second 5-year period, they will provide at our request and contingent on successful negotiations for fair market value compensation, they'll continue to provide services. If we agree to pay fair market value and they decide not to provide services, then Central Health can exercise a purchase option that we'll discuss in more detail in just a moment. And this is also a significant, I think, benefit to us and a significant protection to our population and to the community, the purchase option. So let's talk about that now. Seton grants to Central Health an option to purchase all of the teaching hospital assets, all the equipment and so on, during a 1-year option period beginning on the date on which Seton has actual notice of a Seton event of default. In such an event, the purchase price for the hospital will be their cost that they incurred to construct and equip the hospital, less any amortization or depreciation that they have already recorded against the hospital as an asset, and less their investment in the transition funds. In other words, we'll get a reduction in the purchase price for those funds that Seton used to pay for its transition costs. And Seton also agrees to assist us in securing the transfer of any and all licenses necessary to operate the hospital. We also have an option, in addition to events of default, we have an option to purchase the hospital under a Seton breach. In other words, a material non-compliance with the agreement. And that option would also be during a 1-year option period beginning on the date when we have actual notice of the breach. Under this option, the purchase price would be appraised fair market value less, again, Seton's investment in the transition funds. So that would likely be a higher price paid for under the breach as opposed to the event of default, but it's still a significant advantage to us. And then carrying that on, if they fail to provide the post-termination services as they've already, or that they will agree to under the master agreement, they further grant an option to purchase all of the teaching hospital assets if they fail to provide that during that second year. When we agreed, we would pay them fair market value, but they declined to provide the services. And in that case, it will be the same appraised fair market value as under the material breach section, less their investment in the transition funds. We lose the purchase option if Seton terminates the master agreement due to a Central Health default. We lose the option. Or we lose it if Seton is unable to invest all of its transition funds due to an action or omission by Central Health.
John, can you give kind of an example of what it would mean by that? In other words, we would just fail to pay the, or what would we do that would be an admission or an action?
It could be, for example, failing to make an IGT with available funds for a Deseret project. Yeah.
Okay, so then they wouldn't, be able to have, okay.
Right. One of the other things, benefits that we think we've gotten in this agreement is we have the option to sue for damages or for specific performance in lieu of termination. And so rather than choosing to terminate the master agreement, we also have the option to simply sue them for specific performance. For example, if we're in a post-termination period and they are providing services and then they stop providing services, we can sue for injunctive relief to have a court order them to do specific performance to carry out those services, or we can sue for damages, for example, to recover. We could step in and take over the operation of the hospital or providing services through another provider and step in and do that and recover the damages from it. So that has been an extensive walk through the master agreement. Again, it was our intent to really capture all of the significant provisions of the master agreement in a way that we could all talk about them a little bit more easily. And at this point, I'm going to turn the presentation over to Trish.
So I think a couple, whoop. It went away.
Yes.
Yes, please.
Thank you.
Thanks, John. So a couple of things. I think that we've talked about transparency a lot, and I think it's, that over the course of these last 12 months, there have been many ways that we've had, input from the public. We have the agreement that you see, or that's been presented to you tonight, reflects really an understanding about what we were going to do that was put in writing a year ago in April under the letter of intent, and then was carried out through Proposition 1, which was put to the community in November and approved. So what we've been doing is really focusing on implementing that vision and that agreement and that plan that we had. I want to just reiterate a couple things we've talked about in terms of transparency. We did receive the Silver Leadership Circle Award from the state, and I think that's a really important point. I know I hear a lot of discussion about transparency and what that means, but we've never had, up until now or recently, a standard that said, what does transparency mean for a governmental agency? And we met that standard as set by the state, so I think that that's very significant and not something that we should ignore. We know that as a member of the CCC, we're committed to ensuring that its decision-making and reporting are transparent. We've talked about the different ways that will occur through monthly reporting here, all of the actions that you will take as a board to implement the CCC and to continue to operate through the years. There are going to be many, many opportunities. In fact, there will be, in some respects, duplicate opportunities for information to be presented at CCC meetings that are open to the public and to this board. And I just want to mention that although the Texas Open Meetings Act does not apply to the CCC, we did solicit input through a public survey process, and we incorporated that input into our efforts here. And the CCC bylaws include the following to ensure that the public has access to open meetings, that members of the public may attend public meetings of the board of the CCC. Public meetings shall be conducted at least every other month, and notice shall be posted on the corporation's website. I did mention before that the CCC will have its own website. In the interim, before that gets established, all the information will be posted on Central Health's website, and it will be easily recognizable and accessible. On terms of next steps, the rollout will continue as follows. Again, 2 weeks ago, we did a presentation on May 1st, which kind of tried to recount and recap for us where we are today and why we're here today talking about this master agreement. On the 22nd, you will have the third presentation of this series. That will talk about external analysis, in other words, input that we receive from entities and individuals external to us that have allowed us to take a kind of step back and look at what we're doing and see if it's the right thing to do and how it compares to efforts that might be happening around the state and around the nation. We're going to talk about Seton's mission alignment and how their business model is changing. We've talked about that in the past, but I think it's important to reiterate that. And then how these new agreements compare to the existing agreements. And we touched a little bit on that tonight, but we want to go through a deliberate process of explaining the difference between essentially the contractual nature of the relationship we have under the current lease with Seton and what this new agreement looks like going forward. On May 24th, the legal documents that underlie the presentations that we're making to you will be available. I think as John mentioned, or maybe it was David, I can't remember, that they're fairly dense documents, and we're trying to present these I guess, synopsis and discussions with you in a way that a layperson can understand, because even if you're an attorney, it takes a while to slog through them. I think slog is a pretty apt word. And then on May 29th, the board will consider the agreements that have been presented to you for approval. So between now and then, there's an opportunity for folks to continue to give us input, and there will be citizens communication at the next meeting, of course, as well as the meeting on the 29th.
And Trish, these will be posted on the web, tonight's presentation is going to be on the website.
Absolutely, if it's not there already.
Okay.
And as well, the presentation for next week will be.
And
Understood.
can they provide, the community, can they provide comments through our website? Yes?
Yes.
Okay, just want to make sure that if
Yes.
people out there listening or people out there sitting right now want to provide any comments on the presentation tonight, that if they just go onto our website, they can do that. Okay,
Yeah,
thank you.
that's a great way to do it, because then it's all captured in one place, and we can collate it and provide it to you.
Or they can come to next week's meeting also.
Absolutely.
Okay.
Absolutely.
Okay. All right, any other comments or questions from board members? Yes,
I have a
Katrina?
question. First, thank you. This was a good presentation, and for a, I don't know how many page document, 35-page document, a nice overview. I had a question about the governance provisions, and I'm looking at pages 7 and 8, where you talk about reserve powers. So, and this gets at some of the transparency issues that Trish was just talking about. So I just want to make sure I'm clear and I understand what this is saying here. So the reserve powers, these 18 items, which includes things like approval of the annual budgets, purchasing and fiscal policies, termination of the covered population, future DSRIP projects, approval of coordination funding of FQHCs. All of those items will come to this board.
Yes.
This board will discuss them in public session or public meetings and vote on them before the CCC board would take action or implement.
This board has, these are reserved to this board, so this board has to make a decision. I don't think it can make a decision unless it's an open meeting.
So so the budget,
Right.
the CCC budget, let's say. This board is going to consider that budget before the CCC operational board could take action on it.
You
It
mean
could
in
not-
terms of implementation?
Could not be approved without
Right.
your,
Yes. The CCC board will make the budget recommendation
Right.
to this board
But you can't spend money.
until the board's approved.
It'd probably work the other way. They would come to us with a budget that they had agreed on.
proposal.
And then you could, a proposal that you could ask questions about and say no to.
Right.
If you want to.
Which is kind of what we do now. Staff
So-
puts together a budget for
Right.
us. It goes
It
to,
is.
yeah, okay.
Absolutely it is.
Okay.
Same with determining the covered population
Yes.
Mhm.
or future DSRIP projects.
Yes.
You would, I look at you because I know you're
Mhm.
involved with the CCC and all the work
Mhm.
that's going on there, but you, the CCC, would maybe consider DSRIP proposals
Correct.
that you'd bring them to this board, and then this board would make decisions that would affect whether you could implement or modify or move
Yes,
forward.
and I think that the only difference is instead of Central Health making those proposals in isolation, we are now making them in joint collaboration with our partner, Seton Healthcare Family, because all of those decisions affect the direct delivery of care, which impacts how we serve the community and impacts how they serve the community that we're in partnership with them for.
But in terms of like the tax funds that our board is responsible for,
That's Central Health's decision.
will the CCC be able to expend funds expend funds, do anything with those funds without this board's approval?
No. The budget has to be approved in advance before funds can be spent.
And I
Once
think,
the budget has been approved.
The budget has
They
been
will be able to do that.
Once this board approves the budget,
right. And-
then the
Once the
CCC board could
budget
take.
has been fully approved.
Yeah.
Right.
And the other thing that is, I think, an interlocking nuance here is that the services agreement establishes the current level of services that Seton is providing to us. That can't be changed without our agreement. So, without your agreement, without Central Health Board agreement. So, this puts in place now what the services we get now, which cannot be changed, which was one of the principal things that we talked about early on, that the services they provide now had to be continued to be provided at the same price that they were getting now. So they can't change those services without you approving that.
Okay. All right, thank you.
Mhm.
Thanks. John.
Other questions or comments?
When will we see the other ancillary documents, the
Next-
services?
On the 22nd. On the 24th. They will be presented on the 22nd,
So-
just like these were today. The documents themselves, we don't expect to be finalized until the 24th.
Okay.
But you will receive an overview, just like you have
Right.
today, of all of the content, if you will. But the actual, making sure every I is dotted and every T is crossed and everything's correct in the agreements, that will be on the 24th. Making sure everything's connected and referenced properly.
Okay,
Good work.
thank y'all very much, appreciate that.
It's a
This
really
is-
big help.
So next week, again, before y'all leave, next week, are we going through, tell me what the process will be for next week.
We will have another presentation for you that
Uh-huh.
has the lease agreement and the service, and the ancillary services agreement.
Okay,
As
so,
well as some other, you'll hear comments from those I just mentioned before about Seton. We'll talk a little bit more about their changing model. We will hear from
Oh, Seton will
Dr.
be here too?
Yes, Seton
Okay.
will be here, Dr. Aguanobi will be here.
okay,
So we'll have a little bit more, kind of some wrap-up information about the whole of the arrangement, not just the agreements.
okay. Thank you,
Mhm.
thank y'all.